Good afternoon, everybody. A very warm welcome on behalf of Bristol Law Society. For anybody I've not met before, I'm Nicholas Lee. I'm a cost lawyer at Paragon Costs Solutions, and this is your annual Bristol Law Society costs update. Just by way of a bit of admin, the slides will be sent afterwards, so don't feel like you have to take too detailed notes. This is being recorded. Obviously, it's a webinar, so your faces won't be seen, and I will anonymize any questions that you may ask. I understand that when you close this presentation, you'll be asked to give some feedback, and if you could give feedback, that would be great. And as honest as you'd like to be will be very welcome from my perspective. It'd be helpful to know whether this is actually helpful or anything else that you might want from BLS or Paragon in the near future. And of course, we've got our usual chat function, and if all goes well, this should be about a 45-minute presentation. There is plenty of time for questions at the end, so feel free to use the chat function if you've got any questions. So without further ado, what are we covering? I won't read all of this. You'll see there what we're covering. This essentially has been, this agenda has been produced by reference to some cases that have come out in the last 12 to 18 months that I think are important for you all to know in terms of your day-to-day job. So the idea is that this cost update will be very practical and won't just take you through the law. It'll be things that you need to know in your day-to-day practice. So we're going to kick off with good reasons to depart, and I'm mindful that we've got a wide range of experience on this webinar. So at all stages, I'll try and give you a bit of a insight as to the law as well. So just a quick reminder as to the cost management rules in terms of revising cost budget. CPR 3.15a says that a party must revise its budgeted costs upwards or downwards if significant developments in the litigation warrant such provisions. Now, I've highlighted two parts of that. First of all, the word must. It is not optional. It could be fatal if you don't revise your budget if there's been significant developments. The rule don't say should, the rules say must. So if there has been a significant development, you must revise your cost budget. However, the second part of that is if the significant developments warrant such provision. So if, for example, there has been a significant development, but in fact, from a cost perspective, it doesn't change what is anticipated moving forward, then there's no requirement to revise your budget. But if there has been a significant development that will cause your cost to either increase or decrease, then the rules require that you must revise your cost budget. So that is 3.15a. 3.18, in any case where a cost management order has been made, when assessing costs on a standard basis, the court will have regard to the receiving party's last approved or agreed budgeted costs for each phase of the proceedings. And it's important just to pause there because it's a question I often get asked. If a budget is set at £60,000 for future costs, is that a total budget for my client to incur? And the answer is no. The budget relates to each phase. So if, for example, you are set a budget of £10,000 for disclosure and you spend 12, you will only get £10,000 unless there is good reasons to depart. So it applies to each phase. You can't say, I overspent on this phase and underspent on another phase, so it balances out. That's not how it works. B, the court will not depart from such approved or agreed budgeted costs unless there's good reasons to do so. And we'll come on to explore what may be a good reason. And the court will take into account any comments that are made at the CMC in relation to the incurred costs. So these are the rules. You must revise your budget if there's a significant development, and the court will effectively hold you to your budget unless there's good reasons to do so. So there is quite a bit of guidance on significant development, so I'm not going to cover this extensively. The two cases I quote in the middle, Sharp and Ahuja, are probably the two most helpful decisions on significant development and give some very practical examples. But I think we've got to a point now where there is a common sense approach that's adopted. I remember in the early days of cost management, the courts were setting quite a high hurdle for adjusting budgets. But more recently, and I say recently in the last at least 5 or 6 years, the courts have taken a very common sense approach. So examples such as new expert evidence, more disclosure than anticipated, more witnesses than anticipated, extended length of trials, amended pleadings, etc. So those sort of obvious things that are plainly a significant development and would give rise to additional costs, going back to the wording I took you through earlier, that would give you ammunition to revise your budget. And Master Davison, I think, summarised this quite neatly in Ahuja. He said, as a matter of policy, it seems to me that the bar for what constitutes a significant development should not be set too high because otherwise parties preparing a budget would always err on the side of caution by making over-generous assessments of what was to be anticipated. And I think that's absolutely right. I remember when we were first producing budgets almost 10 years ago, the contingencies sometimes could be 6 or 7. Every application under the sun was put in as a potential, because everybody was nervous that if they didn't put in those applications, or they didn't put in all those potential factors, that they wouldn't be allowed those costs at a later date. And of course, that's never what was really intended by cost management. Your budget is meant to present what you think is a reasonable sum of costs, reflecting the directions that you're seeking in the case. And if something happens which is contrary to that, or there is a significant development, as Master Davison says, the bar for achieving significant development should be set relatively low, so that logic will prevail and a common sense approach can be adopted. So I think the bar for significant development is rather low. However, the bar for good reason is perhaps a little higher. Sadly, there is not a lot of guidance. The Court of Appeal was asked to give some guidance in the Harrison case back in 2017, and the Court of Appeal did what they often do, which is to say, as to what constitutes good reason, I don't want to provide any generalized guidance or examples, and it can be safely left to the cost judges having regard to each individual case. So not very helpful in my view. I think what perhaps would have been helpful on good reason is to give some examples and to give some guidance, because otherwise these things have to be resolved through satellite litigation. But sadly, that is what the Court of Appeal said. The only guidance they gave was that the court shouldn't be too lax or overindulgent, so not too easygoing and not too harsh, and suggested something along the lines of the Denton test, that being the test for relief from sanctions at 3.9, even though this isn't a sanction type situation. The court said that is the sort of test that should be applied. And in my view, that's actually quite a high hurdle. And as I said, there's been very little guidance as to when the courts will apply good reason. So I wanted to share this case with you. That was a case I was involved with in Manchester before the regional cost judge. It was this time, well, it was early last year, but we only got the transcript a couple of months ago. And if any of you are cost lawyers and get the regional, the Association of Cost Lawyer article, you would have seen this featured last week. So these were the submissions, and this is a case where my client was the receiving party, the claimant, and they had exceeded their cost budget, but they felt there was good reasons. And this was the submissions that we made. In relation to disclosure, we said that this was exceeded due to the exercise being far more complicated, protracted, and voluminous than expected. And you'll see there the figures. We had a budget of 17, but we actually spent £41,000. And it's important to mention that when it came to disclosure, there wasn't a single significant event. Actually, disclosure was protracted, prolonged, and happened on numerous occasions. And as I said to the court, had we applied every time we received further disclosure, we probably would have ended up making 10, 15 applications. So that was what we said was good reason in relation to disclosure. The witness budget was exceeded due to the fact that there were more statements, and those statements took longer, primarily because of the additional disclosure, because every time there were new documents, those had to be considered and addressed by the witnesses, because of course that they were dealing with the relevance of that disclosure. So in relation to the witness phase, we'd spent £46,000 as against a budget of 25. And also our trial preparation costs went up, primarily because of the additional preparation resulting from the additional disclosure and the additional witness evidence. And this is where it got even more substantial, because the budget was 21,000. The actual costs in our trial preparation were £72,000. So as I say, we asserted that there wasn't a single significant development, because of course the first hurdle we had to overcome was, well, why didn't you apply at the time? And we said there wasn't a single significant development, the series of events which amounted to good reason. And also these events happened very near to trial. I think the latest disclosure was about 7 days before trial. And as I said earlier, had we applied at each stage, every time there was a something that changed in terms of the additional witnesses or anything else, we would have ended up making about 15 applications in the 6 months leading up to trial. In terms of our approach to presenting this argument, my instructing solicitor did a very detailed witness statement. And what he did was he identified the assumptions in the present page. and then explained how the case differed from those assumptions. So an easy example was lever arch files of disclosure. In the present H, they specifically said that they anticipated receiving 5, and in one tranche of disclosure alone, they received 25. And as I said, they continued to receive disclosure. So that was the sort of thing we set out on our witness evidence, as well as dealing with the law. We specifically covered the facts. And of course, there was a huge amount at stake there. You know, if you add up the amount by which my instructor solicitor overspent as against the budget, there was about £100,000 at stake on this one point. And what the court held was that a budget, as we know, should be amended during the course of litigation and before the budget is exceeded. And it's important to stress that this isn't a case of us saying, well, you can overlook significant developments. Ultimately, as the court identified in this case, is that you should apply, and you should apply before incurring the costs, not after you've incurred the costs. So that should always be remembered. However, in this particular case, there was good reasons for not applying, as I've set out. The court said that there were further documents produced, which led to the involvement of e-disclosure experts. This in turn led to additional witnesses. And of course, all of this increased the amount of trial preparation. And the court described what we said was a snowball effect. And the disclosure started and witness evidence got larger, and then trial prep got larger. So therefore, that's why the trial preparation phase was most exceeded, if you like. And the court accepted that. So on the facts of the witness statements and the submissions, as well as the documents, the court was satisfied that there was good reasons to depart from the budget. Now, the court didn't go as far as to say how they would then approach that, because of course there is no guidance in the rules as to what the court should do if good reason is established. Do you conduct a traditional detailed assessment and assess every item? Well, I don't think anybody wants that. Or should the court adopt what I suggested should be a hybrid approach, which is to say, okay, well, what would be a reasonable sum having regard to the good reasons that have been established? So a far more broad brush exercise. Now, we didn't get that far. And what the court said is, well, go away amongst yourself and see if you can agree a figure, and if not, come back. But as it happened, we were able to agree the figures. So the lessons we learned, assumptions in the present page are critical. So often, for using the disclosure phase, for example, I see descriptions such as standard disclosure. Well, that means nothing. Standard disclosure could be one document, or it could be a million. If you end up getting more documents than you thought, you are not going to be able to show a significant development or a good reason, because your budget doesn't set out how you've arrived at that figure. So really important that for each phase, you give yourself ammunition to be able to revise your budget if necessary. Set out how many witnesses for both sides. Set out the amount of disclosure you expect to receive, whether that's in volumes of documents or in gigabytes, however you want to present it. You need something to be able to show how you've arrived at your budget, and you need to apply that through every stage. As I've said before, a failure to revise the budget could be fatal if you try and rely on good reasons at the end. If there's not a good reason why you didn't apply when the costs have been exceeded, then that could in itself be fatal. And as I said earlier, it's a very low hurdle. So if something does change, make the applications to the court. They are being far more receptive to changing budgets. Good reasons, I've said, is a higher hurdle, and will apply the Denton test. But hopefully common sense will prevail, particularly if the evidence supports your position. I don't think the courts will take generously to parties constantly asking for good reasons and saying, well, this just took a little bit longer. There has to be something of substance that is supported actually by the file. This case also delivered another gem in dealing with insufficiently pleaded points of dispute. And it's the first known decision, at least to me, that applied Master Gordon Saker's consideration in Ainsworth. Now, Ainsworth is a case where it was a solicitor and client dispute, and effectively it was found that the paying party hadn't sufficiently set out their objections. And it's often relied on in inter-party assessments. And often it's said, well, Ainsworth doesn't apply because it relates to a solicitor and client assessment. As I say, this is the first known decision that actually has applied Ainsworth in the context of an inter-party assessment. We, as the receiving party, complained that some of the objections were too brief and didn't comply with the practice direction. And what the practice direction essentially says is that for each objection, you have to set out what you're objecting to and the amount you're offering. So let's say routine letters to the claimant, there are 28. You have to say, these are too high, we offer you 26. It's not sufficient just to say, as they did in this case, well, your pre-action costs are excessive and disproportionate, and instead of, I'm picking figures out of the air, but instead of £50,000, it should be £20,000. We said that is way too brief. You have to set out specifically what you objected to and why. So we put them on notice in the points of dispute that unless they set out their position, we would seek to have them struck out. We exchanged skeleton arguments. We had a case management hearing, but again, the paying party failed to properly set out specifically what items they're objecting to. So we said to the court that in fact, all of the objections to the incurred costs, because this is a budgeted case, all of the objections to the incurred costs should be struck out because we didn't know what we had to respond to, and the court accepted that. The court said that a party has the right to know the case they had to answer. So as the rules set out, the points must be specific and concise. But all of their objections to the incurred costs were struck out. Now, this was particularly critical in this case because at the CMC where our budget was set, the judge setting the budget made adverse comments in relation to the incurred costs that said that they appeared to be excessive and disproportionate. So we were prepared to push back on that. But in fact, we didn't need to because the points of dispute were entirely struck out. So you can almost read between the lines here. All the incurred costs were allowed as claimed because effectively the points of dispute were struck out. We had good reasons to depart from the budget in relation to the phases that I'd set out. So we were on to a winner here. So that's why we didn't get any further with establishing the good reasons test, because the other side were already on track not to beat our part of this offer. So this is an important case, two reasons. One, an example of where the courts will apply good reason, and secondly, an example of where the courts will robustly take action where a party is not complying with the rules. So talking of non-compliance, I'm going to scare you all with some stories of misconduct. And the title of this particular slide is "Winning is Not Everything." This is a defendant who won a claim or defeated a claim, I should say, because the claim was statute barred. However, both parties had failed and succeeded to some extent, and both sought their costs. I think the claimant sought 80% of their costs, and the defendant said, no, we are the winner here, we should get our costs. And essentially, the reason why the claimant said they should get some costs is because it was found that they were a victim of fraud, and therefore the claim would have succeeded but for limitation. And of course, the defendant was, because of the allegation, guilty of serious misconduct in relation to the lies they told when given evidence, and the court was particularly critical of the witnesses. The claimants asserted that there was a plethora of legal and factual contentions on which the defendant lost at trial. They knowingly deceived the claimant. That much of the defendant's evidence was contrived, embellished, and invented. And if they were awarded their costs, it would reward them for advancing a dishonest defence. So even though ultimately the claimant's claim failed because it was statute barred, it should never have been brought in the first place, the manner in which it was defended and the dishonesty meant that the claimant said not only should the defendant be deprived of their costs, but the claimant should get their costs. And of course, the defendant responded as you would expect and said, well, look, I particularly like this. On the spectrum of deceitful behaviour, the conduct was at the less serious end, and I wasn't sure there was a less serious end of deceitful behaviour. But of course, the defendant ultimately said, well, this claim should never have been brought. So how we defended it should be irrelevant to some extent because it was statute barred, it should never have been brought. And the claimant said, no, we were successful on most points, but the defendant, of course, was the overall winner. So what the court said in this case was that, look, we have to stand back and look at this in the interests of justice and fairness. There were lots of complicated and specific facts to this case, but what was actually just in this particular case was no order as to cost. So even though it could not be disputed that the defendant was the winner, because of their conduct, they were deprived of their right to recover costs. So as the title says, winning is not everything. It's the way you win, which will be important in the court size. And if you're seen to be lying or there's fundamental dishonesty or deceit, then I think you could be in some difficulties. And there's another example. This was a case of Ahuja, again, from last year. The claimant brought a claim for £8 million, which was dismissed. D1 brought a counterclaim for £31 million, and they succeeded to the extent of around £2 million. So ultimately, on paper, defendant, again, was the winner because they dismissed the claim and they were getting £2 million. But again, the court was critical of all the key witnesses and found that there were fraudulent representations made to the claimant but there had been no inducement or reliance. So that's why the claim failed, because even though there were fraudulent misrepresentations, they said that there was no reliance on them. What the court ultimately concluded was that whilst and as I say, the court was critical of all the key witnesses and said that whilst the basis of the claim was false, it was in turn met with lies. But that said, the court couldn't ignore the defendant's conduct and their failures. It would have been wrong to say, well, you've brought a claim for £31 million as a counterclaim, you've got £2 million only of that. And there are, of course, considerations of exaggeration. So it would have been wrong to have disregarded their conduct and ultimately the level of success that they achieved. So the court concluded that a fair result in these circumstances was that the defendant should be deprived 25% of their costs due to their dishonesty. There was then an argument about a Part 36 offer because the defendant had beaten their own Part 36 offer of £800,000, and therefore they wanted the Part 36 sanctions being a 10% uplift, indemnity costs and everything else. And of course, the claimant said no. In the circumstance of this case, that would be unjust. The court said no. In fact, Part 36, as it's supposed to be, is there to penalise and reward. So the defendant had beaten their Part 36 offer, and therefore the usual consequences would apply. So from the expiry of the relevant period, they would get cost on an indemnity basis, the higher rate of interest, and of course, the additional £75,000 because it's capped at £75,000. So another example of where the court are taking quite a robust approach, despite the fact that there could be no doubt that this was very successful for the defendant, they were still deprived of at least 25% of their costs, of course, subject to assessment. And costs are no exception. There was a case late last year where the paying party in their points of dispute said, please can you identify who has signed the bill of costs, and also you haven't provided sufficient information about the fee and has undertaken the work. And the receiving party, rather than say, here's who signed the bill of costs and here's who worked on the file, most of us cost lawyers will use software that, if necessary, we can produce bills that say this work was done by grades A, B, C, or D, or we can click another button and it will say this work was done by this particular fee earners. Now we tend to group it, or historically we might have grouped it by categories of fee earners to try and keep it more contained. But what the court said is, in fact, a paying party is entitled to know specifically who done the work, because, for example, it could show in a document schedule that a grade C fee earner has worked on the file on one day and then on another day. But in truth, that could be two different grade C fee earners doing the same work, and therefore there could be duplication. So by identifying the specific fee earners that did the work, the paying party can properly assist the costs. So when these objections were raised, the receiving party, rather than just say, okay, here's the information you've asked for, declined and said, no, we're not going to amend. And the court said, well, I'm going to strike out the bill of costs. It's important to mention that they didn't strike out the entire claim for costs. What it effectively meant was the claimant had to go and start again. They had to go and amend the bill, reserve it, and of course there was all the wasted costs, including the cost of an appeal, all for the sake of just providing a little bit more information that probably would have taken about half an hour. So the real moral of this story is sometimes it's just better to cooperate. Quite often I'm faced with questions and people asking for certain information and clients saying, well, why should we provide it? And I often flip that on its head and say, why shouldn't we? Because if a court ultimately finds that we have not been cooperative, bearing in mind the overriding objection and everything else, then this is an example of how things can go wrong. So I think sometimes we can be all guilty of being too aggressive, when in fact sometimes the cooperation is the best thing, and to go into a hearing with an entirely straight bat is the best place to be. So again, an example from the cost world as to the sanctions that are available if the parties aren't compliant with the rules. And I should say that the practice direction does say that you should provide details about the fee earners and who's undertaken their work, their qualifications and everything else. So an important decision to read for any cost lawyers out there. So that is the scary stuff on misconduct. Of course, that won't apply to any of you because you will all conduct your cases perfectly. So that's just for you to remind your opponents of. I'm going to move on to our favourite subject, which is proportionality. Again, for anybody that's new to the cost world or junior in their careers, the test for proportionality is at 44.35. Proportionality remains one of the most subjective tests, and as the case law will show you in a moment, it's not got any easier. costs incurred are proportionate if they bear a reasonable relationship to sums in issue, value of any non-monetary relief, complexity of the litigation, any additional work generated by the conduct of the other side, any wider factors such as reputation and public importance, and any additional work undertaken or expense incurred due to the vulnerability of a party or witness. So I think it's fair to say that value is the one that people look at first and foremost, because of course, if you've got a claim that's pleaded at £5,000 and your costs are £50,000, then straight away they say, look, no sensible person would have ever spent £5,000 to recover £50,000. But of course, there are cases where money isn't the only thing, and maybe it's a nuisance claim where a neighbour is making so much noise, it's keeping your family awake, and you're all struggling with, you know, your well-being because of the conduct of a neighbour or something like that. And in fact, the monetary sum of say £5,000 is irrelevant. Ultimately, you wanted an order requiring your neighbour to stop making that noise. So that's where the complexity of the litigation and the non-monetary relief can be relevant. And of course, you've got sort of boundary disputes where there's no money in dispute, and trying to establish what is a proportionate sum in those is very difficult. So that is proportionality. It's very subjective, and no one ever really knows what the court's going to do. But one thing that people quite often felt comfortable with is, well, look, if you're dealing with a £1 million claim and your costs are £200,000, surely you're safe. And Kazakhstan in 2015, before Mr. Justice Lega, was an example of how proportionality can still be applied even in high value cases. I'm not going to read this entire paragraph, and as I say, the slides will be circulated, but I do want to draw your attention to the middle part, which I've highlighted. And what the court said, just move my face, is the touchstone is not the amount of cost which it was in a party's best interest to incur, but the lowest amount which it could reasonably have been expected to spend in order to have its case conducted and presented proficiently. Well, that was a new test. No court has ever said that a proportionate sum must be the lowest amount, but that's what Mr. Justice Leggett said. So this gave rise to all sorts of problems, because what you had was, you had your typical disproportionate claims that I mentioned earlier, where the damages were very low and the costs were very high. Then you had the flip side, where the claim was worth a lot of money and the costs were by monetary sums proportionate, but the parties were saying, or the paying party was saying, oh no, this isn't the lowest possible sum you could have spent, so it must be disproportionate. So Kazakhstan, it's fair to say, was causing receiving parties a little bit of a headache. And in comes Mr. Eggers QC last year in Discovery Land Company, who disagreed respectfully with Mr. Leggett, said, I'm not certain why the touchstone of reasonableness or proportionate cost must be the lowest amount which a party could reasonably have been expected to spend, and concludes that expenditure which is within a reasonable and proportionate range is still reasonable and proportionate, even if it's not at the lower end, which I think is absolutely logical. In any case, there will be a range. It is never a specific sum, and you can't say it's the lowest sum. But having regard to the factors at 44.35, if the costs are within a range of what is reasonable and proportionate, then that's fine. It doesn't have to always be the lowest sum. Now, this may not be the smoking gun, because this was in the context of cost management and not in the context of an assessment. But I still think this is a helpful decision and a logical one. And I certainly don't think that there's anywhere in the rules that says that proportionate cost must be the lowest sum. It has to be a reasonable and proportionate sum, and there has to be a range that one has in mind. So that is the latest on proportionality, and I think the Discovery case was perhaps quite a relief to lots of people that deal with receiving party work. And for any of you that are new to the cost world, again, I just want to remind everybody of the leading Court of Appeal authority on proportionality, which is that of West, and the court set out the approach that should be applied where the costs are disproportionate. So what the court said, the Court of Appeal said in this case, is that judges should go through the bill line by line in the usual way, assessing what is reasonable, including court fees and AT premiums and everything else. West was a case involving AT premiums, but I'll park that for now. If the total of that line-by-line assessment is disproportionate, then a further assessment is required. Now, what happened before West is there was all sorts of different approaches. There were some decisions from cost judges in the SCCO who were saying, well, I'm going to decide what is a proportionate sum and given a figure, and that's what you got. Some judges going back through and doing another assessment. What the court said is, in this case of West, is that there should be a further assessment, but what the court should do is consider specific categories of costs. So helpfully provided some examples such as expert reports or specific periods where particular costs were incurred or particular parts of profit costs. So it's open for the paying party to say, well, in view of the fact that these costs are disproportionate, can I invite you to reconsider this particular part or that particular part? So a paying party needs to have that fallback position of directing the court the specific costs that they think are disproportionate. Once the court has reconsidered any specific points, the resulting figure will be the final figure. So that's it. You deal with a line-by-line assessment, then you deal with specific categories, and that is your final figure. And the court said that there'd be no further point in standing back and, if necessary, undertaking yet a further review by reference to proportionality, because that could create a risk of double counting. So I think this is a very helpful and very logical decision. As I said, some of the previous authorities were being far more bullish and saying, I've assessed this at 60, but a proportionate sum is 40. It's very broad brush and means that the parties have incredible difficulties trying to advise their clients on what a proportionate sum will be on assessment. So I think this West approach is logical. And again, back to the point I made earlier with points of dispute, I think if paying parties are going to say that costs are disproportionate, then they need to set out, as per West, what categories of cost they want the judge to reconsider at the end of a line-by-line assessment. And I very rarely see that being set out. So a word of warning there in relation to West. So that is proportionality. I can see some questions popping up already. So just a reminder that the Q&A function and the chat function is there, but I won't look at it until the end because I'll lose my place and I'll make a terrible fool of myself. So I'll pick those up at the end. Next subject I want to cover is interest. Now, some of you may have seen this slide before, and this is designed to show the difference in terms of the court's approach to interest, depending on whether you do PI or commercial work. So I'm not going to take you through all these cases in detail, but I just want to highlight or give you the highlights and help you to understand how we've reached where we are. There was a Court of Appeal authority back in 2002 that essentially said pre-judgment interest can be awarded. So we're dealing with pre-judgment interest, I should say, in this particular presentation. Of course, most of you will be aware that once you get a judgment for costs, you get interest at 8%, but we're dealing with pre-judgment interest here. Bin Kemi was, again, a leading authority, thanks to the Court of Appeal, that said that where a party has paid their solicitor's costs during the course of proceedings, that the court can award, and should in this case award, 1% above base rate from the date of each invoice. Now that can be obviously quite a considerable sum. If you've got litigation that costs millions and the client's paid that over 5, 6, 7 years, then you can get interest from the date of payment at a rate typically 1% above base rate. So Bin Kemi remains a helpful authority in that respect. And then there was the High Court decision of Jones, and this is one where I think it was Hugh James in their CFA provided for disbursement funding, if you like, a credit facility that was provided by the law firm, and said that they would charge their clients 4% above base rate for that. High Court said that was reasonable. So you've got two examples there. Client funds litigation to get 1% above base rate. If the solicitor funded the litigation by way of a credit facility, they were, according to the High Court, entitled to recover 4% above base rate. However, in Marlborough and Nosworthy, these were two cases only a couple of years ago, 2020 cases, where the claimants had taken out disbursement funding loans. And in both cases, the court said that the interest on those disbursement funding loans was not recoverable, which was surprising because, of course, that is a loan that the claimant has had to take out to fund his litigation. So why shouldn't it be recoverable? And you compare that with the final example of Sharp, and the court in Sharp concluded, and it's in the same year, that the court may order interest on costs of state before judgment. Well, we know that, thanks to Powell, and it's common ground that this will generally be exercised where parties had to put up money, pay its solicitors, and has therefore lost the use of that money, always had to borrow it. So Sharp was a commercial case. So what the courts have essentially said is that, well, if you borrow money in a commercial case, you can recover pre-judgment interest. But in a PI case, if you go down the route of a disbursement funding loan, you can't recover the interest. And to my mind, there was no logic for that distinction. And it's often been a slight bugbear of mine. And I think, personally, I think it stems from the fact that historically, a lot of PI lawyers have funded their clients' disbursements without cost to the client. But times have changed. Success fees are no longer recoverable inter partes. There's more scrutiny on rates and proportionality. I think gone are the days where lawyers can afford to fund all their solicitors' disbursements, but I think that some of these judges perhaps are of that mindset that, well, if that was good back then, it should still be good now. The tide is shifting slowly. There have been two recent decisions, one late 2020 and one recently late 2021. Sadly, in both cases, the claimants didn't actually recover their interest. But what the court said is, yes, we do have discretion to award prejudgment interest on a disbursement funding loan, but in both cases, they said that the evidential burden of reasonableness was not met. So I think that's important, because what that does is it gives the green light, but it requires that parties seeking to recover it need to provide evidence of reasonableness. So, I ask myself, what does that look like? Well, I think you're going to have to show evidence of the litigant's means of funding the disbursements without a loan. So if, for example, you've got a client that is got £100,000 worth of savings, well, surely it would have been more beneficial for them to have used that than borrow money, ? Unless, of course, they were putting that money aside for an extension, ? But that's the sort of evidence that you would have to give. What was my client's means of funding this, but for a loan? Second test might be, well, were they eligible for a traditional loan? Because some of these disbursement loans attract interest rates of around 15%, for example, whereas a traditional loan that you might get from your bank would be at a much lower rate. I have no idea what they are at the moment, but they would certainly be lower than 15%. So you may need to provide evidence of whether a traditional loan would have been capable of being obtained. But of course, that's not a straightforward answer, because even if your client was capable of obtaining a personal loan, was it in fact more advantageous for them to take out a disbursement loan? Because disbursement loans, and I'm no expert on disbursement loans, but quite often they are contingent, they're also deferred. If you take out a traditional loan, well, then you have to start repaying it immediately, whereas a disbursement loan is repaid at the end and typically would be deducted from damages, so the client doesn't have to physically find the money. So there are all sorts of other pros and cons that must be considered. And finally, evidence that the rate charged was reasonable. So I suspect there is an element of shopping around to say, we looked at personal loans, this wasn't attractive. We've looked at disbursement funding, this was the product we chose, and why. And I think that providing that evidence may well see a reported decision in the near future that says, yes, we have discretion, yes, it was reasonable, and this is what we're going to award. And I think that's fair. I don't understand why in commercial cases they can recover it and in PI cases they can't. So there is hope, and hopefully these cases will give any PI lawyers amongst you the information you need to be able to try and recover any disbursement funding interest that your client is liable to pay. Security for costs and cross-undertaking in damages. Now, apologies to anybody that's new to the cost world or junior in their career, because this is quite a heavy subject. But I'm going to deal with it as briefly as I can, and I'll try and draw your attention to what is most relevant. This is a claim where there were over 500 claimants, as you can see, and there were a number of defendants, and the claims varied in value from £36,000 up to over £10 million. So huge range in valuations of claims. Defendants were seeking security for costs, which I will come on to, but there were a number of factors that the court had to consider. For anyone who doesn't know what security is, it's a defendant that says, if the criteria is met, we want the claimants to have to show us that they're going to have the ability to pay our costs if we win. We're entitled to security for costs because we don't feel that the claimant, as it seems to us, is able to pay, so we require security. So that is a tool that's available. The first thing the court had to consider, Mr. Justice Newey, was whether the claimant should be jointly or severally liable for the defendant's security for costs or costs generally. Should that be split 500 ways to reflect all the claimants, or should it be split another way by reference to the value of the claim? And what the court said is that the fair approach in the circumstance of this case was a several liability by reference to the value of the claim, prorated, but declined to deal with apportionments. Now, I think that consideration is perhaps helpful for anybody out there that's dealing with multiple claimant or defendant cases where you've got defendants that want to try and get out of litigation, and there's a question as to whether they're jointly or severally liable or how you apportion that. The court do consider that in this particular case. And I think it's logical that where you've got values that they're quite defined and able to be apportioned in this sort of way should be apportioned. So that was the first helpful thing that Roe dealt with. But on to the real crux of the decision. The question was, should security be provided by the funder? So this is against a third-party funder. And there was about 250 of these claims that were funded by a third-party funder. Should security be provided, and if so, how much? And what the court concluded was that, having regard to CPR 25.14, which deals with security for cost, the criteria had been met, and therefore security could be ordered. I'm not going to take you through the criteria, but it's there in the notes if you need it. The question was whether there was a real risk of non-payment if the defendants were successful. That's the test. And what the court concluded was that the funder hadn't provided any evidence of their financial positions. There was no evidence that they would be able to meet any cost liability. There was no evidence that the claimants would be able to meet any cost liability. And the AT policies were not a complete answer, because there was a risk they wouldn't pay out in full or at all. And it wasn't a criticism of any particular AT insurer, but of course there could be all sorts of reasons why an AT policy may not ultimately pay out. There's usually clauses that if a client's dishonest or whatever else, that they don't have to indemnify the client. So it's not a complete answer, the court said, and that's been a bit of a theme. Sorry, my slides froze there. So the court said it was reasonable to order security, and the amount of that would be 75% in cases where there were allegations of fraud and 70% where there weren't. And the reason for that distinction is that if you bring a claim and you make allegations of fraud and they're unsuccessful, then you're more likely to be liable to pay costs on the indemnity basis. So that's the reason why the court provided a higher percentage in those cases where there were allegations of fraud. You'll see there security just shy of £4 million, only up to the third CMC. So you can tell from that we're dealing with pretty significant sums. And when considering the amounts, the court did give credit of between a half to 2/3 of the AT cover available, but not the entire amount. So that dealt with the quantum exercise and whether it was reasonable to make an order for security for cost. Again, that wasn't too controversial. We move on to the more controversial part, and this stems from that there were a number of cases that aren't in these slides where a funder has had to put up security and said, well, fine, if we have to put up security for, say, £2 million, that's money that we could have spent elsewhere. We could have been funding other cases, but we can't because we've had to put £2 million in security in this case. So we want a cross undertaking in damages. And they said, and what that means is, if we put up £2 million and ultimately the claimants succeed and there was no requirement to give that £2 million over, then we want to be able to seek damages for our losses as a result of having to give security. And there were a number of cases where the courts were saying, fine, you can have a cross undertaking in damages. And I don't know what the result of that was, but I should imagine that if the claim succeeded, the third party funders were saying, well, had we invested this elsewhere, here's what we would have earned. So this is our claim in damages. So, potentially satisfy litigation. Now, in this particular case, in first instance, the court said that they wouldn't allow a general cost undertaking. It wasn't appropriate, but they did provide a limited cost undertaking to cover what was called external costs of providing security, which was known as bonding, which involves AT insurers providing a direct indemnity. So what the court said is, well, we're not going to provide you with an absolute outright cost undertaking in damages, but in relation to these specific costs, we will give you a cost undertaking. So that's what the court said at first instance. If anyone wants to better understand bonding, then by all means go and have a read of that decision. Now, this was appealed by both sides last year. The claimants appealed the refusal to provide the general cost undertaking in damages, and the defendants appealed the award of the limited cost undertaking. So nobody was happy with the underlying decision. And what the Court of Appeal said is that the cost of litigation funding should lie where they fall, i.e., if there is a cost to the funder, that is their own costs. The provision of security should be included in the funder's business model. So when they're working out their pricing, they should factor in the cost of having to provide security, because these applications become more and more familiar. A funder should be able to show that they can satisfy any adverse cost order. Going back to the criteria that was considered in the first instance, was that the funder didn't show that they had means to meet an adverse cost order, and they said that the Court of Appeal said that a funder should be able to show that, and if they cannot, they should be able to pass on the costs of putting security in place to their clients as part of their business model. And they said it should only be in rare and exceptional cases that a cost undertaking should be required, and even rarer where there are litigation funders. So really putting a nail in the coffin and saying it should be pretty rare, and they didn't give any examples of where that should be appropriate. The underlying court was correct to refuse the general undertaking, but should not have required the undertaking for the equivalent cost. So there was no undertaking provided. So this is a helpful decision, as I said, in terms of that sort of joint and several liability for multiple parties. It's a helpful case in that respect. Helpful if you want to understand circumstances in which security may be given. And it's also helpful for anyone that's involved with third-party funding and having to deal with funders to know whether the funder is likely to get security or a cross undertaking for providing that security. And the Court of Appeal say in most cases the answer should be no. So apologies if that was a bit heavy or advanced for anybody, but for at least one of you, I hope that was helpful. Moving on to another favourite subject of everybody's is late acceptance of a Part 36 offer. You'll be pleased to know I'm running ahead of schedule. This is my last section now, so if you've got any burning questions, feel free to pop them in the box. And as I say, I think this was a Part 36 anomaly, if I can call that, and unintended consequences. Is the case of Pallet early last year. And what the defendant did is they purposely accepted the Part 36 offer, the claimant's Part 36 offer late, and sought to rely on Part 36 13(4)(b). And that rule provides that unless it considers unjust to do so, the court should order the claimant gets their cost up to the expiry of the relevant offer, and then the offerer gets their cost thereafter, unless, of course, it's unjust to do so. So general rule is if you accept an offer late, claimant gets their costs up to the date of acceptance, and thereafter, whoever's accepted the offer late will be paying costs. That's the general rule. But of course, this, unless it considers unjust to do so, enables the court to consider the issue of costs. So what the defendant did in this case was purposely accept the offer late and then tried to argue that the claimant's cost should be disallowed from an earlier date because they had refused to engage in settlement. Of course, I'm not going to take you through all the law, but there is a lot of case law out there where parties have unreasonably engaged, refused to engage with ADR and mediation, and they've either had their costs reduced or disallowed for failing to engage in ADR. It's quite a serious subject in the courts at the moment. So the defendant said, no, they shouldn't get all their costs and they should be deprived from March 2019 for not engaging in settlement. The court in this case said, well, whilst, yes, I can consider whether another order for costs should be made, on the facts of this particular case, I'm going to decline, and it was reasonable for the claimant to refuse to negotiate until they had further information. So on the facts of this case, the court said, no, the usual order for costs will be made. Claimant gets their costs up to the date of the relevant period, and then, of course, they would actually get it for the additional day because it was a defendant that was late. But what this really highlighted was an opportunity, as I say, for a party to purposely accept an offer late to have an argument about costs, and that surely must be unintended. What's really important to remember is that if a Part 36 offer is accepted late, the rules are very clear. There is no automatic order for costs. It says that liability for costs must be determined by the court unless it's agreed between the parties. So there is no automatic authority for costs if you accept late. It has to be resolved by way of a consent order, or it has to be determined by the court. But it certainly, to my mind, seems unintended that a defendant could accept an offer late and then argue about costs. I mean, who can be rewarded for doing something late? It seems very bizarre. But as I say, that is what the court said in principle the defendant could do, but on the facts of this particular case, they were unsuccessful. And I suppose I asked myself the question is, more perhaps the intention of the rules was that the argument on cost liability was limited to the period after the expiry of the relevant period. So in other words, the usual rules apply, claimants get their costs up to the expiry of the relevant period, but the court can consider the cost thereafter. Of course, in Pallet, the defendant went way back before the Part 36 offer, but maybe the intention of the rules was that the court just are able to consider those post late costs, if you like. But as I say, it seems to be an unintended loophole. I've seen a few people trying to use this, so certainly something to be aware of. But the real takeaway from this is if a part solicitors offer is accepted late, the parties need an order dealing with liability for costs because you don't have an automatic authority for costs. And that is the cost update. We are at 50 minutes, so I will just look at the chat and Q&A. This is the point at which someone says to me I've been on mute the whole time, which would be incredibly embarrassing. Let's have a look. Okay, so we've had a question. You mentioned that parties must apply to revise a budget downwards as well as up. When would this happen realistically? Is this something perhaps the defendant might want to do if they admit liability? You wouldn't suggest, e.g., that the parties should do so if maybe expert evidence is the same and there was no need for a joint statement. So to answer this question, I've seen very few applications to revise budget upwards, let alone revising downwards. In fact, I've not seen a single application to revise a budget downwards, but you're absolutely right. The rules say you must apply to revise your budget upwards or downwards if there's a significant element. Now, to answer your question, I think if I were the claimant, even though the rules say you must, I suspect they will be less inclined to apply if, as you described, the expert evidence is the same and therefore there's no need for joint statements and the experts don't need to attend trial. That would potentially be a significant development. And I very much doubt that the claimants will volunteer to go and apply to vary their costs. I think that probably what is more likely is that a savvy defendant will remind the claimants of their obligations and will say, can we agree on variations? Because one thing I didn't mention is when I was giving the talk earlier, is that whilst you have to apply to vary your budget, it can be agreed between the parties. And the new rules require you to try and agree it between the parties before you apply. So hopefully with some sensible conversation with the other side, you'd be able to agree some small variations. But as I say, realistically, I'm not seeing parties applying to revise their budgets downwards. And the consequence, if you're a claimant and using your example, the experts fall away because the experts essentially agree the position, is that if you get to trial and you win and everything goes great and you're within your budget, you run the risk that the defendant says, well, yes, whilst you're within your budget, there was a significant development and you didn't revise your budget downwards. So that is good reasons to depart. And we want to now be able to attack all of your cost budget for that phase because we've no idea what a reasonable sum should be having regard to that development. So again, it's a dangerous game and watch this space. But yes, to answer your question, there aren't very many applications in that regard, but there should be. There was also another question that I'm reminded that was posed before the seminar started, which was, do I have any insights on what's happening with the fixed fee regime? The short answer is no, in that I'm not on any sort of committees or anything else where I get extra insight, but for everyone's benefit, the government had a consultation back in 2019 about extending fixed recoverable costs. The MOJ did a report last September around that time proposing that fixed recoverable costs would be extended to all claims up to £25,000, dispense with this idea of an intermediate track, but instead said that for straightforward claims up to £100,000, they could be caught within the fast track. So essentially the fast track could be expanded to include those claims valued between £25,000 and £100,000 that were described as simple. And has suggested that the Rules Committee work with them to deliver these reforms. But sadly, there was no real guidance on what these band allocations would be, what simple cases would be, and a bit like the Court of Appeal guidance I referred to earlier, said that further clarity will emerge over time in light of experience. So that to me says huge amounts of satellite litigation with people arguing over whether it's a simple claim or not, whether it should sit within the fixed fee regime or not. And as is always the case, the devil will be in the detail. And sadly, I suspect that unless the rules are prepared in such a way that provide absolute clarity, I suspect we will end up with years of litigation. And by the time we finally get to a point of understanding what it all means, it will probably change again. But perhaps that's just the pessimist in me. But there's no news as yet as to when it will certainly be implemented. I think that I saw something from the last minutes of the rules committee that suggested that it could be implemented as early as October this year. But I think there are all sorts of other considerations that are taking place, and naturally with these things is not as straightforward as one hopes, and there are other considerations in relation to quotes and everything else that the parties will need to think about. So yeah, watch this space. So sorry I don't have any special insights there, but that's the general information that's available. I'm just going to stop sharing and see if there have been any other questions, which there hasn't. I hope you've all learned something new today. As I said, there will be some evaluation, so if this was helpful, let me know. If it was useless, let me know. If there was something you'd rather I covered, let me know, because the feedback is incredibly valuable. I hope you're all well. I hope next time we have this conference we might be able to do it in person. And thank you again, Bristol Law Society, for putting this on for you, and I wish you all well. Many thanks.